All right, a crucial hearing is just now hours away in Fulton County, Georgia. Judge Scott McAfee saying that today, the hearing tomorrow, he will address scheduling for the trial in the Georgia election subversion case. It's all happening tomorrow. The question is whether or not the case should be broken up. Remember, there are 19 defendants after all. Joining me now to discuss all this and what it could mean for the trial, National Security Attorney Bradley Moss and Jamil Jaffer, former Associate White House Counsel to one President George W. Bush. Everyone, glad you guys are here. This has been on my brain all day. Well, thank you for over a month at this point in time. 19 defendants. All at once, she intended to try them together. Within 6 months, Fani Willis said. Many lawyers chuckled, not because it wasn't possible to do so, but just thinking about the logistics here. This is a time when we don't even know if Mark Meadows is actually a part of the entire thing yet. Is it practical to think that this could actually be a trial with 19 people in a courtroom, not broken up?
I think it's very unlikely at this point, and not just because of Mark Meadows. You've also got Jeff Clark. You've also got speedy trial requests from Ken Chesebro and from Sidney Powell. You've got any number of pretrial fights that Donald Trump's going to bring. You've got Rudy Giuliani's likely challenges over information. This is going to be a logistical mess. And so what will be interesting to see tomorrow, and this is one of the things the judge asked Fani Willis to be prepared for, is if you were to do all 19, how much time would you realistically need? It's not happening in October for all 19. I'm sorry. There's just no way it's going to realistically be happening.
Well, by the way, not everyone wants it. I mean, to your point about speedy trial, I mean, it can work. If the prosecutor said if it was only up to her, maybe it could, right? But it's not. It's also the defendants who can say, I want to go fast. And others are saying, I don't want to hear anything about October and nothing about 2023.
No, that's exactly right. The president has made clear that he doesn't want this trial to go forward anytime soon, and he's going to do everything he can to throw sand in the gears, the former president, and slow this thing down and make motions and try to get, appeals rolling. He's going to have a very hard time doing that, but he will try and throw everything he can at that. Now, I think this whole Chesebro move and Sidney Powell seeking a rapid trial, speedy trial, is going to cause problems as well, because now that they've moved forward, they have to have their trial done under Georgia law or begin by a date certain in early November. That means that at least some part of this is going to roll out. That means that evidence is going to be in front of a jury pool, in front of the American public, regardless what Donald Trump wants or doesn't want in terms of his timing.
Because it's televised, right? I mean, that's, my father always says, revolution will be televised. That's not what he means. He's talking about this, of course, although maybe the revolution will be televised. I just don't know. But when it comes to this actual trial, it will, in fact, be televised. And you're right. The jury pool will be impacted by what they're seeing. And I've had multiple co-defendant cases. You know what happens when one's not there? They go, look who's not here. And they point to the empty seat and they say, aha, that's who really did it. So if you're Trump, if you're anyone going after the original people who might go first, are you kind of nervous?
Yeah, because with this trial, if this happens in late October, early November with Chesebro and with Sidney Powell, it's going to be basically a preview of everything that will come out eventually in the trial of Donald Trump. Fani Willis will be able to bring out any number of those witnesses. She doesn't have to bring out all of them because these two people aren't part of the entire conspiracy. They're parts of pieces of it. But she'll be able to trot out any number of those individuals and show it on live television. There'll be OJ, exploded exponentially in terms of media coverage, and it'll all play out just as we're slowly getting, closer and closer to the first primaries and first caucuses.
If it's like OJ, and everyone thinks about OJ, and you think about walking or driving behind and following the white Bronco. I remember OJ as like a months-long voir dire, right? And hours long of having people answer questions, even qualified to be jurors. And that was a case that captured the national attention. But this might even be more known to some degree. Let's just play for a second, fellas. What if it is broken up? How is it broken up? I mean, are you looking along who has similar charges? Is it who are the lawyers versus everyone else? Is it the state employees versus everyone? How is that broken down?
Well, look, at a minimum, right, you got to get these two speedy trial requests dealt with and moving at the beginning, right? Now, who else comes along with that, I think, is a hard question, right? But you can also divide this up in a variety of ways. You laid out a couple, right? I think at the end of the day, what the way this plays out is Fani Willis is going to try to get as many of these done as she can as quickly as possible. She wants to get her evidence out there. She wants to put it on the table, get some convictions in the books so everyone else starts flipping and ultimately turns and points the finger at the former president.
I mean, is it harder, though? This is a RICO case. So her whole thing is this is one big criminal enterprise. I can imagine if she's trying to build that, you want everyone to be in the room where it's happening. You want to be able to say, here are all the people. Now, the Georgia Dome is not available, I don't think, for this trial. But you want them conceptually to be around for this moment. If that's the case, I mean, does this actually, if it doesn't go all together, is her case undermined?
I don't think so, because she can still, through the various overt acts that she outlines in the indictment, through any number of witnesses she can bring out, she can still show the larger overarching conspiracy, and she can basically trot out and practice what she would ultimately put forward in a case against the former president. She's going to get all these witnesses out there. They're going to deal with cross-examination. She'll see what worked and didn't work, and if they get the convictions, it's almost certain some people, some of these co-defendants will start to flip, seek deals, and it'll only put more pressure on Donald Trump.
This might explain in part why someone like Jack Smith said, I'll take one defendant, Alex, for $200, and I'll put him, that was a Jeopardy reference, it's still too soon for me, that's fine. But then having it be in Washington, D.C. with one defendant. But now they're in front of that judge, Judge Chutkan. And what they thought might happen, they're now saying in a filing tonight, in fact, has happened, that he is tampering with the jury pool. He's making extrajudicial statements of some kind. We don't know all the details of it. This, of course, Chutkan warned could lead to an earlier trial date, if true. But her ruling today was to have a hearing in the future to talk about how one posted on the docket. Where are we going with this?
Yeah, I mean, look, this is a whole train wreck of filings. So apparently the government this morning made some sort of a filing under seal referencing these sensitive materials. And they also made their filing to seal that filing. None of this is on the docket. She granted their motion, and then all of a sudden comes sailing in from the right-hand side the defendant saying, look, we didn't get a chance to object to this. So she vacates her order, lets them file a response, has a briefing schedule, a short one, right, very quick one, but she's given them a chance to have a bite at the apple and said to everybody, look, you got to consult with the other side when you're making these filings. So it's clear that you've got to confer. Well, you have to at least say whether you did or did not confer, right? So a little bit of a complicated procedure here, but at the end of the day, the point is she's going to move this thing along. She's going to give everybody a fair shot, but this thing is going. That March 4th date's still on the books.
Some people ask how many bites one should get at the apple if you are theoretically intimidating witnesses or tampering with the jury pool.
Part of it here, and let's be honest, is it's Donald Trump and he's a former president. The government's going to give him every benefit of the doubt here. The judge is going to push, going to hold back on taking any action because no one wants to be that person sanctioning, gagging, censoring a former president. But what'll be interesting to see once we finally see whatever this underlying motion was, and this was all motions about talking about a discussion, what was it that they were bringing up? What was the relief they were seeking? And if it was, in fact, related to his posts, were they seeking some type of pretrial violation? That's what everyone wants to know right now.
Of course, little does everyone know that most of the law is about motion practice, everyone. Brad Moss, Jamil Jaffer, thank you so much. And by the way, the reference was Gil Scott-Heron for all of you out there. I know my stuff. Thank you. See, Daddy? I listen. President Biden also now is going on the offensive with a multi-million-dollar ad campaign. Will it win him more support with the election on the horizon? We'll talk about it next.